Good afternoon, although I guess it's afternoon in California now too. So congratulations and welcome to the We the People National Challenge this year. We're delighted you're here. We're pleased about your accomplishment. We're going to introduce ourselves and ask you to introduce yourselves. Then we'll listen to your opening statement and then have a chance to ask you some questions and conclude with some feedback. My name is Dan Taubman. I'm a senior judge on the Colorado Court of Appeals in Denver, Colorado.
I am Dave Adler. I'm president of the Old Tourist Institute and also adjunct professor of law at University of Idaho. And I've judged the national finals for many years. It's always a pleasure to interact with such bright, talented students such as yourselves. Congratulations on your achievement at making it this far under these adverse conditions. Nice to be with you.
Don, you're muted.
Here I am. I'm Donald Rogers from Central Connecticut State University, where I teach history. I judged We the People for many years at the state level and the national level. And I admire your achievement for making it to the national finals under our challenging circumstances. And I look forward to hearing what you have to say.
We'd like you to introduce yourselves now and tell us about one thing you were doing before the pandemic hit, and also to have one of you introduce your teacher.
Good afternoon. We are Unit 4 from Amador Valley High School, representing the Golden State of California. My name is David Yerda, and we'd like to thank you for listening to our testimony today.
And one thing that you did before the pandemic?
One thing I did before the pandemic, like with access to pools, I was able to swim every day. So I'm missing the water a little bit.
Hello, my name is Emma Reddy. One thing I did before the pandemic is I went to Starbucks every day.
Good afternoon, my name is Rashab Raj. And before the pandemic, I'd go to the park and play basketball with a lot of my friends, but can't do that anymore.
And hello, my name is Kevin Andrews, and before the pandemic, like Rashab, I used to go outside and play basketball with my friends, but can't do that now, unfortunately. And once again, we'd like to thank you for listening to our testimony today, and we'd also like to thank our coach, Ms. Sklar, and our timer, Ms. O'Brien.
Thank you.
Thank you.
So, let me now read the question, and then we'll hear your opening statement. Article 1, Section 4 of the Constitution provides that state legislatures can determine the times, places, and manner of holding elections for senators and representatives, yet gives Congress the power to make or alter such regulations. What are the advantages and disadvantages of a uniform election process? What responsibility do state legislatures, state election officials, and citizens have in maintaining free and fair elections? What are the advantages and disadvantages of the trustee and delegate theories of representation as they apply to congressional districts? You may begin.
While a uniform election process has advantages, we don't support it entirely because of the advantages of our federal system. We instead advocate for increased federal oversight because it would best protect voting accessibility while maintaining state autonomy.
The main advantage of a uniform election process is that it protects voters against state encroachments. Shelby County v. Holder 2013, which struck down the pre-clearance formula in Section 4B of the Voting Rights Act of 1965, showed the drawbacks of minimal federal oversight. The decision allowed states such as Alabama to purge over 20% of their registered voters, effectively disenfranchising thousands.
However, we don't support a completely uniform process because of its main disadvantage, the loss of policy experimentation. Federalism allows states to test policies as laboratories of democracy and implement successful ones. For example, after Oregon successfully implemented vote by mail in 2000, 4 other states followed its lead. A completely uniform process would remove any opportunity for positive experimentation.
We therefore call for increased federal regulation of elections without eliminating state autonomy. Senator Amy Klobuchar's proposed Natural Disaster and Emergency Ballot Act of 2020 mandates nationwide early voting and non-excuse absentee ballots to protect voters during the COVID-19 pandemic. These measures, if continued, would maximize the advantages of a uniform election process while minimizing its disadvantages.
Because we do not have a uniform process, states and citizens must help maintain free and fair elections. State legislatures and election officials have the responsibility of increasing both voters' confidence that their actions matter and their political knowledge.
State legislatures must increase voters' confidence in their actions by eliminating gerrymandering because it creates uncompetitive elections that decrease the value of votes. According to a 2019 Marquette University poll, 72% of people support having nonpartisan redistricting commissions draw maps. This would reduce gerrymandering and increase voter confidence, and is a step state legislatures must take.
State election officials must increase the convenience of elections to encourage more people to participate. According to a 2017 Pew Charitable Trust survey, 15% of people don't vote because they either don't know how to register or because it is inconvenient. State election officials could increase registration and therefore turnout by streamlining voter registration as much as possible.
With the right to vote, citizens must hold representatives accountable through elections. As Publius wrote in Federalist 51, a dependence on the people is the primary control on government. Without citizens fulfilling Publius's ideas, corrupt representatives in positions of power would be able to violate the rights of citizens.
Because our system of elections is inherently flawed through gerrymandering and low turnout, our legislators have become equally flawed in representing people. Representatives can act according to two main theories: delegate, where representatives reflect the views of constituents, and trustee, where representatives act in the interest of the entire country.
However, both of these theories have shortcomings. The delegate theory's main disadvantage is that it isn't practical, as according to the US Census Bureau, congressional districts average over 750,000 people, making it impossible for representatives to truly embody the will of their constituents. The trustee theory's main disadvantage is that it ignores the role of the people in interacting with the government.
Thus, we support political theory, which according to a Tufts University law article is where representatives act according to their constituents on salient issues, but follow their own judgment on issues with a low degree of public opinion. This maximizes the advantages of both theories. Representatives don't entirely ignore the will of the people, and they act according to their own judgment to reach the common good.
The relationship between representatives and the people is realized through our system of elections and is foundational to our republic, but it does not maintain itself and will fall apart if left alone. Benjamin Franklin did not describe our government as a republic if representatives can keep it. He promised something far more challenging: a republic if you can keep it. Thank you.
Thank you very much for your opening statement. I'd like to follow up on your comments in your opening statement about gerrymandering. And can you tell us about the difference between Supreme Court cases that dealt with one person, one vote on the one hand and partisan gerrymandering on the other?
Certainly. So Baker v. Carr of 1962 establishes the principle of one person, one vote. And that's different than our question today with partisan gerrymandering, because one person, one vote just means that a district has to be proportional in terms of how much weight their votes has. Rather, instead, political gerrymandering has to do with the comparative strength of political parties.
And while Baker v. Carr of 1962 ruled questions regarding the population of districts to be justiciable, the Supreme Court has a long history of cases regarding partisan gerrymandering to be non-justiciable. Veith v. Jubileer of 2004 was the first overturned Davis v. Bandemore of 1986 and ruled that partisan gerrymandering did not have a judicially manageable standard and thus fell under the political questions doctrine of Baker v. Carr. And Rucho v. Common Cause of 2019 most recently continued the same trend of the Supreme Court finding partisan gerrymandering to be a non-justiciable political question.
However, in Justice Kagan's dissent in Rucho v. Common Cause, she points out that state courts can be a way for states to combat political gerrymandering. A couple of months after the Rucho case, a case reached the North Carolina Supreme Court, Common Cause v. Lewis, in which they used the state's free and fair elections clause to strike down a politically gerrymandered map.
As you think about the fears and reasons and concerns that motivated the framers to write Section 1, Article 4, do you see any similar concerns or fears in our time that would justify Congress using its power to regulate elections in states?
I think there are definitely fears with states abusing the power that they're given under Article 1, Section 4 of the Constitution. Specifically, I'd like to point out in Georgia, when the then Secretary of State, Brian Kemp, in the gubernatorial election of 2018, used the state's exact match law to purge 53,000 voters from voter rolls because the law stated that a hyphen or a misplaced initial could allow a person to be purged from the rolls. And later on, he won the election by only 55,000 votes. And his opponent, Stacey Abrams, called Brian Kemp a remarkable architect of voter suppression. So clearly here, the state of Georgia was abusing its power that it has over elections and possibly changed the entire direction of the election.
I think another similar fear to add on to Emma's point can be seen regarding the current coronavirus situation, where I believe Congress has not acted enough to set a sort of federal baseline that all states must have when conducting elections. I would support implementing a nationwide vote by mail, as states such as Illinois, which held their primaries on March 17th, that did not have a statewide vote by mail system, saw turnout decrease by over 500,000 votes compared to the 2016 primaries. And I think if Congress were to set these federal guidelines, I think elections could be administered in a much better way should another crisis like the coronavirus situation come up in the future.
So following up on that, I mean, what's the limit on Congress's power over the manner in which state elections are held? Can it reach gerrymandering? Can it reach voter suppression? Is there any limits on Congress's power in theory under the Elections Clause?
Well, according to Federalist Paper 59, written by Publius, he writes that ultimately the power to control and conduct elections is ultimately a power that resides in the federal government. And we see with Arizona, the Intertribal Council of Arizona in 2013, where the federal government's attempts to federalize registration with the National Voter Registration Act preempted state initiatives to do so. So while technically there are no limits on the federal government's power to interpose themselves on state governments' attempts to encroach voters' rights.
However, we don't advocate the federal government to take complete control over our election system. If we look at the Natural Disaster and Emergency Ballot Act that was proposed by Senator Klobuchar, it allowed for up to 21 days for early voting. And states like Virginia signed a law last week that would allow early voting to go up to 45 days. Maintaining a uniform election process would not give states this chance to experiment and expand voting opportunities for its citizens.
Did the Shelby case throw up any barriers for congressional control over state elections?
Well, the case Shelby County v. Holder of 2013 really allowed the states to have a lot more leeway in how they conducted their elections. This allowed states such as Texas, which passed their Senate Bill 14, which was a strict photo voter ID law, only 2 hours after the Shelby County v. Holder case was actually decided. Mm-hmm. So Congress now has less of a way to actually combat the states in their voter ID laws or their strict and discriminatory voter legislation, and the states have more of a say.
But legally speaking, the National Congress has every right to implement a new legislative effort to modernize the Voting Rights Act of 1965. This was echoed in Chief Justice John Roberts' majority opinion in Shelby County v. Holder, specifically that Congress could pass an updated version of the preclearance formula. So in terms of what power the national government actually has, they can step in and have their place back in regulating elections.
That's time.
I see your time is up. Thank you very much for your presentation. We enjoyed it very much. We're going to provide you with some feedback right now. I enjoyed your discussion about the advantages and disadvantages of a uniform election process and saying that there should be some kind of a hybrid system established. That makes sense. I see that. I'm glad that you mentioned that Oregon and 4 other states have mail-in voting. I was extremely disappointed that you didn't mention Colorado, because Colorado is one of those states, but not a big deal. Seriously, I was glad to see that you mentioned Senator Klobuchar's present bill to deal with the pandemic, to show that this is a current issue today in terms of the extent to which the federal government should be involved with voting. And I liked your discussion of the delegate and trustee theories and the hybrid political theory. And I'd like your discussion about, as well, about the partisan gerrymandering cases and how the Supreme Court has held that that's non-justiciable, but on the other hand, some state courts, including North Carolina, have held that it is. The one thing that I would have liked to have heard more from you about is the constitutional amendments that deal with voting rights, like the 15th Amendment, the 19th Amendment, the 26th Amendment. That would have added a little bit of more depth to your discussion, but overall, I think you did a very nice job. Professor Rogers.
Thank you.
So I thought that I enjoyed your presentation. I liked the discussion of the gerrymandering question. And again, I thought your answers were very responsive. The difference between gerrymandering and one person, one vote. I thought you really ended up with a spectacular answer to my question on Shelby, where you pointed out, I mean, one hand, Shelby struck down current use of the Voting Rights Act, but you added, I think quite appropriately, that Justice Roberts opened the door for Congress to act, update the Section 4B, and maybe this would be constitutional. I thought that showed very, very a good knowledge of that case. I would have liked to heard a little bit more about the constitutional reasons why Justice Roberts said that the court had right to sort of strike down this congressional legislation. But I thought, again, you understood the dynamics of that case very well. So good presentation.
Thank you.
Thank you.
Thank you.
I agree with my colleagues. I very much enjoyed your terrific presentation. You showed notable strengths in terms of your responsiveness to our questions. You all participated fully. I really appreciated your very balanced review of the uniformity versus uniformity question of elections, like the fact that you readily invoked the Federalist Papers. And I think when you turn to the question I asked, you demonstrated real strength when it came to understanding the broad powers available to Congress to regulate state elections, particularly in situations where some of the similar fears and concerns and reasons harbored by the framers have been manifested in our time. I like very much the reference to Brian Kemp in Georgia, and I think you grasp very nicely the effect of his manipulation in purging the voter rolls, and certainly you were able to quickly cite Stacey Abrams' criticism, well-warranted criticism, and that you're very much on top of recent developments, including the Virginia action just very recently, as well as the Texas voter ID law. So I like the fact that you showed a real command of the principles of law and the power available to Congress to respond to state actions, and also the fact that you had a good grasp of the implications of gerrymandering and the powers available to Congress to respond if they so choose. So I really appreciated your presentation. This was well balanced and, as I say, very impressive. You're obviously well trained. That's a credit to your teacher. And I wish you good luck the rest of the way. Take good care. Thank you.
Thank you.
Thank you.
Thank you